to Simply Legal. I'm your host, Geraldine Warren, longtime Medfield resident and practicing attorney here in Medfield. Each month, I present a topic that I hope you viewers find not just interesting, but also useful. Last month, I presented a topic on estate planning, and so to follow up, today will be on probate. And I am thrilled to have with me Patrick McDermott, who is the Chief Magistrate and Registrar of Probate here in Norfolk County. Welcome, Pat.
Thanks, Geraldine.
Yeah. Do you want to start by telling the viewers what being the Chief Magistrate and Registrar of Probate entails?
Sure. The Registrar of Probate is an elected official. We are all elected every 6 years. I was first elected in 2002, re-elected in 2008, and just recently re-elected to a third term in 2014. And so being an elected official, my main goal is to provide access to justice for those people in Norfolk County that need the services of the probate and family court. Some of the things that we do in probate court, we deal with all family law related matters, mostly divorce, child support, child custody issues, adoptions, change of names, and then we do the probate side of things too, relative to estates when people pass away. All estates of people who live in Norfolk County, when they pass away, their estates are filed at the Norfolk Division, and we administer those estates pretty much on a day-to-day basis. So
just so the viewers know that the code was amended, the Uniform Probate Code was amended in 2006, right? 2006?
Yeah, it was about 5 to 8 years ago or so.
And then just finally in 2012, the entire code went into effect. So that might have had, those changes might have affected your office in a lot of ways. Did you find that?
Yeah, the code, when it was changed, it was, for some people, it was a radical change because probate law had been a compilation of statutes, of case law, of rules, regulations, and for years the legislature had debated the adoption of the Uniform Probate Code, which was adopted in many other states throughout the country. Massachusetts hadn't adopted it until recently, and when we did adopt it, we had to come up with a way in which to administer it. The code is pretty much a succinct volume of how to administer estates, and we had to adopt our practices to that way. And I say it was a positive influence on the way we practice law. It makes filing estates, I think, a lot simpler. There's a freer flow of the process. It makes it a lot easier, I think, for both for litigants or customers as well as attorneys to get their clients appointed to represent the interest of the estate, to gather and marshal the assets of the estate and make distributions in a more timely fashion. So I think it's been a positive change. It was a little bit of a culture change for a lot of practitioners out
there. Probably more for lawyers than for...
We had lawyers, and I felt bad, but there's a lot of lawyers who had been practicing for years who kind of throw their mercy at the clerk's office and said, just help me, let me find out how to do this. And the more and more we learned about it, because we learned together, we partnered with the bar to try to figure out how to administer this code. And we found that through practicing with lawyers, with members of the public, with the judiciary, we found out a pretty good way of getting things done.
So as you were saying that, the changes in making it more accessible and easier to administer and distribute, why don't we go ahead with some of the changes? Like, you want to start with the voluntary administration?
Sure. Yeah, voluntary administrations is the simplest form of an estate. It pretty much hasn't changed substantively in terms of how you get appointed. In fact, let me qualify that. You don't get appointed when you're under a voluntary administration. Years ago, prior to the code, estates that were up to $15,000 were eligible to file this paperwork. The code allowed it to expand to $25,000. So your total assets under an estate, if your total assets of the decedent, the person who passed away, were valued at $25,000 or less, your heir, your loved one, can come in and file a voluntary statement of administration. And that's a simple 3-page document that basically lists who you are, what your relationship to the decedent is, the assets that you're looking to marshal for that estate. And it could be as simple as, mom passed away, she had $2,000 in her checking account, she had a car, She had maybe some stocks that were valued, $10,000, $12,000. Provided that all of those assets don't add up to more than $25,000, you can file this statement. Now, I said you're not getting appointed. There is no court appointment for a voluntary. You are just basically volunteering this information to the court to make it a public record that you are willing to step in and administer that estate in a voluntary fashion. So once you have filed that statement with the court, we issue an attested copy of that, which is basically a simple raised seal. You might get that when you're getting a death certificate or a birth certificate. That raised seal, we'll stamp it with the Registry of Probate signature on it. My signature will be on it. And you would be able to take that document to the bank, to the stock company, to an insurance company if you need to do that, and you'd be able to marshal those assets for the distribution. And you still have to distribute according to either the will, which you can either file a voluntary statement with an original will. You can't file a copy with a voluntary. Or if there is no will, you'd be filing it, and then you'd be subject to the Commonwealth's laws of distribution. And so as the voluntary personal representative of the estate, you would then take those assets and pay for maybe the funeral expenses, pay for any other administration expenses, as well as then if there is money left over, you distribute it accordingly to the heirs.
Now, you mentioned if someone didn't have a will and died intestate. Has that changed on who the heirs are now since the code was amended?
There has been an update, and to be honest with you, I've put it out of my mind as to what happened before the code. So I know now they did refine a little bit more, and they allowed more access with stepchildren, I believe, and access to adopted children. So, but the heirs are pretty much delineated accordingly, and it can be multiple of scenarios. But what most people, the average a spouse passes away, and if you die without a will, pretty much your spouse is going to be the heir. Your children are not heirs under those scenarios. But
I think in the previous times it was,
yeah. In previous times, that was one of the changes, is that a child was considered as an heir and received, I think it was 50% of the assets. But under today's code, in that circumstance, the spouse is the heir, gets 100% of the estate. If you pass away and you leave children, no spouse, your children are the heirs. Very simple. It gets a little bit more complicated if you die without any children. No spouse, no children. Then we start going back up the food chain. Are your parents still alive? Because then your parents become the heir. If your parents are no longer alive, then we're going out to your brothers and sisters. If you have no more brothers and sisters, now we're going to your nieces and nephews, and so on and so forth. So at some point, and we do have some complicated estates that get filed, you can have second cousins, third cousins, and then the certain removal that comes in. So it can be very complicated depending on the circumstances, but the vast majority of them are simple estates, that we administer.
Now, on the voluntary administration, before we move on to the other two processes we're going to discuss today, the informal and the formal, in the voluntary you mentioned a car. So you can have a car and $25,000 or less in assets. Is a mobile home, let's say someone has a mobile home, would that be considered a car, or is that considered real estate?
It depends.
Okay.
And I say it because they can be both. A mobile home can actually be a moving vehicle, or it could actually be a standalone house that sits on a slab in a mobile park. So, and I'm not sure the law relative to mobile parks, but sometimes they can be considered a real property, because you could have ownership interest in a mobile park.
And then you couldn't do a voluntary.
You could not. Well, if it's real estate, you cannot do it, no matter what. If there's any real estate involved, even if it's under $25,000, if you own a piece of land that's only worth $5,000, you can't file a voluntary. And I just on the car portion, and a lot of people don't realize this either. If your spouse passes away and the ownership in her car is in her name, there is not a need to file a voluntary either, or any kind of estate. The Registry of Motor Vehicles allows for a transfer without probate of that vehicle. So that's something that I didn't know even until I contacted the Registry of Motor Vehicles.
So they allow the transfer to the spouse.
To a
Can it be
spouse.
to a child or just to the
No,
spouse?
just to a spouse. So
Okay.
that's something that
Okay.
related to spouses, that's a easier thing, so you don't have to worry about filing it. So if the title to a car is in your spouse's name and she passes away, you can
That's good to know.
transfer that through the Registry of Motor Vehicles. And your final intent may be to transfer it to your child. So bottom line is you go to the registry, you get it transferred in your name, and then you transfer that title to your child. So you can avoid probate in that circumstance.
So now we're going to move on to the new informal probate that just went into effect in 2012. And I think a lot of people may not be familiar with it because, as you said, a lot of the practitioners were used to the formal process where there's court supervision. So do you want to just talk about the informal? Because I think it's great. I've used it so many times now since 2012.
Yeah, the informal process, and it allows for access to the courts in a very simple fashion. And basically the only requirement is, and it depends on whether or not one dies testate or intestate, whether with a will or without a will. But under either circumstance, you have to wait 7 days for after the decedent has passed away. You need to file a simple form. Some say it's a little bit complicated, but the form itself is about 5 pages long, depending on how many heirs we have to list. But you file the form, the petition with us, you file the death certificate, you'll file what's known as a bond, and for those that aren't familiar with what a bond means, if you're filing to be the personal representative of an estate, what we require you to do is basically file a bond that says, I am going to be personally liable for the administration of this estate, and if I abscond with the money, if I do something nefarious with it, then the heirs or the beneficiaries would be able to come back and call in that bond, and therefore would be able to recover pursuant to the bond. And that bond is based upon how much the value of the estate is. So in this circumstance, we're thinking of an estate over $25,000. It may or may not have real estate in it. But if you file that, you have all your paperwork in line. And these informals are pretty much for intact estates, that in terms of there's no real controversy involved. Somebody passes away, their children.
You know who the heirs are.
You know who the heirs are. There can't be any minor children of the estate. There can't be anybody who's a beneficiary that's incapacitated under guardianship. And I should qualify that because you technically can, if they are under guardianship, that person can give a consent for the informal to be filed, which is great. But other than those complicated issues that come up, for the vast majority of cases, you can file informally and get appointed within a relatively quick period of time. And it depends on county by county.
And I have to say, your county, because I've dealt with your county and Middlesex, and mostly with your county, it is so quick with your county. I mean, I think I get them within weeks of the appointment.
Our goal is and it's always a struggle because staffing has been a tough thing in all of the courts over the last, it almost seems since I've been in office, we've always had some kind of fiscal crisis that we've had to deal with. So we've had to reduce our staff. But our probate department works tirelessly to make sure that we do get backlogs from time to time. And our goal is always real-time docketing, that if you come in and you file, and if you're at the front counter and you have a client that needs to secure an asset, there's something going on, a bill has to get paid, we'll take that out of line. We'll get that docketed. We'll get it in front of a magistrate, either myself or my first assistant register, and we'll get that appointment allowed. And that's usually the process. But sometimes it can, if the petition gets filed, it can be a couple of days to get into the system, to docket it, get in front of a magistrate to be allowed, and then out to the customer. Yeah. And that's the beautiful thing about the probate process. Now, it takes the informal process and even a little bit of the formal, and we'll get into that later. It makes it a more administrative process, so you don't have to go in front of a judge. You're not looking to bring your client into the court, making a pleading in front of a judge, explaining your situation. It's a very informal process that you get to file the paperwork, we review the paperwork.
And the magistrate is the one that signs off.
And based upon your paperwork as filed, we're going to sign off on that and issue you a certificate or letters of authority. I'm going back to the days of certificate of appointments. Letters of authority for your client to go forward and administer the estate. And What we find too is those letters that get issued, we issue one letter per case as part of your filing fee. Oftentimes there's multiple accounts that need those letters. So for $25 per letter, you can come back and get as many letters of authority as you require to get that done. And sometimes my staff gives out a freebie here and then. So.
I wasn't going to say anything. I wasn't going to say anything.
We're very user-friendly in Norfolk. So.
But, so we have the 7 days. So 7 days after, they can go ahead and try to go ahead and do the informal. What do they do next? Like once they go ahead and get the appointment, or that's what I still call it. But
once you're appointed, you can then marshal the assets. Meaning, if there's a house involved, obviously that house has bills to pay. If you're going to keep the electricity on, the water bill, the taxes have to be paid. Sometimes you might want to list that house for sale, and it largely depends too on whether or not the will itself gave a power to sell. And that's where things get a little complicated. Real estate does cause a little bit of complications to the matter.
Speaking of real estate, I don't mean to interrupt you, but can you use the informal for land court real estate as well as for...
It's my understanding that they have come up with a title standard now that allows you to do under both.
I think you're...
Under the former, when we first started this, title companies refused to accept the informal appointment as a way to do land court matters. But I think they've straightened that out with CADIC and the land court to allow for an informally appointed personal representative to then have the power and the full authority to transfer title. And certainly, when we talk about transferring title, that's provided there's a power of sale in the will. And most wills, if you're good, and I'm sure Geraldine's one of the best in Medfield, that writes up wills, you always want to make sure that there's a power of sale in the will. But I've read wills that don't have it, and I've had to advise people that if there's real estate, then you're going to have to file a license to sell. Which is another layer of what you need, and that's a formal process, and that sometimes confuses people. That you can informally probate an estate, and then move into a formal process like a petition for a license to sell, which is a formal process. So you can go in and out of, and that's one of the things that the code talks about. You can go in and out of the informal or formal. Because
but some counties it's easier to go in and out of than other counties.
And we're trying to work on that.
Norfolk's a lot easier.
We like to sell the Norfolk model statewide. I'm the president of the Registers of Probate, so I meet with my colleagues quite frequently to go about best practices. And my goal is always, and we're elected officials, all of us, all 14 elected registers. I mean, so my goal is always, what puts me in the best light? What's going to make my constituents want to vote for me? And to me, it's ease of access, efficiency, and a place that they know that they can do their business in a public environment that's most efficient. And so I've tried to share that with my colleagues on some of the things that we do in Norfolk that I like. And I've stolen a few ideas. Bristol County does a few things that I really like. Plymouth County has done a few things. I haven't ventured much into Middlesex or to Suffolk. It's a little bit tougher county, and Middlesex being the biggest one.
Yeah, Middlesex and Norfolk is really the two counties I work with.
But we do strive for uniformity. It's one of the things. I've been president now for, I think, 4 years or 5 years, and we have emphasized that. And we have a whole group of new registers that think that the probate code is something that we can really bring in some of our systems and put systems in place that make it a little bit more uniform. And it's mostly for the benefit of the attorneys, because the attorney that travels from county to county really needs to know that there's a consistent approach to administering an estate, and that they don't have to worry about remembering what needs to be done in Middlesex versus Norfolk. So uniformity is something we strive for. We're not there yet.
Okay. Now, so we're at the point where you've got the appointment, you waited the 7 days, you got the assent of everybody, the heirs, and now you've got the appointment. And what about publication? Do you want to?
Yeah, the code prior to this, you always had to publish before appointment. Under the informal process, you actually publish after. We still want to make sure that notice gets given to the world, largely for creditor purposes, that an estate has been filed with the court. And so we typically ask that an informally appointed personal representative will then publish They download their own notice form from our website, and then they self-publish. So they'll go to the local newspaper here in Medfield or in Quincy or wherever the
You even have a
decedent
list.
lives.
I
We
think,
do have a
yeah.
list, and we recommend. I always recommend the local papers only because the goal is to get the word out that a person has passed on and that the estate's being administered at the Norfolk Probate Court if anyone has an interest. And it could be anybody. It could be somebody local that, maybe had a lien on the property, somebody that did services for the decedent that didn't get paid. And then the big companies, obviously the credit card companies need to know. Not that they're looking at the local newspaper necessarily, but creditors have a vested interest in the administration of the estate, and they have up to a year after a date of death to file a claim against the estate in order to get paid. So the personal representative does need to publish that notice. We're hoping, and I see I do follow a lot of the local newspapers, so I do see a lot of the publications being done, which is a good thing, because that is the law. You are required to do it. People will ask, the attorneys don't, the attorneys know, but if a person's trying to administer an estate by themselves, do I have to publish this? I said, by law you do. No one's going to be hunting anybody down if you didn't file. However, you can get in some trouble when real estate's involved. When real estate's involved, we actually in Norfolk, and there's no requirement technically in the code for us to do this, but we've kind of made it our policy that when there's real estate involved, and you come back to us and looking for a license to sell the property, we're going to ask for proof of that publication, that informal publication notice was in fact published. And that's one of those hiccups, and I think a title company is going to look for that too. If there's ever a title question down the road when you're trying to sell property or remortgage it. So I always caution everyone, do what the law asks you to do, and you'll never have a problem.
Now, the final thing would be the closing. So how does that estate get closed in the informal? Do you want to just tell everyone how
This is where we weave in and out. The personal representative is required within 90 days after their appointment to get an inventory of the estate. Prior to the enactment of the code, you were required to file that inventory with the court. You are no longer required to file that. However, you do have a fiduciary obligation to file that with the beneficiaries of the estate, the heirs. To give them notice of, okay, I've been appointed, here's what I've found. After 3 months, we've got stocks, we've got a checking account, we got a house, we get this. And they would list that in an inventory and give that to all the beneficiaries and the heirs. From that inventory, after a year, you're then required to account for the estate. And your account should factor in things like the expenses. Was there a funeral expense? Was there, you had the house upkeep, anything that came in. And there's even administrative expenses. The personal rep may charge a fee. The attorney has a fee. And then the sale of the piece of property could have a realtor's fee involved. But at the end of a year, you're required to account for it. Now, once again, you're not required to file the accounting with the court, technically, which gets us into a little bit of the complicated notion of, do I proceed informally to close the estate or formally? There is an informal approach to closing an estate by just simply filing a closing statement. Very simple. Just say, hey, I'm done. I've done all that I've needed to do, and the estate's been closed. And we just accept that for filing, and we put in the file, done. It's more of a prudent method to file, to close formally. And the reason why I say, especially if you want your fiduciary obligation you want to be relieved of that obligation. As we talked about earlier, you file a bond, and therefore that bond follows you forever until it's formally discharged. And it can only be discharged formally. And so when you file a petition for a formal closing, we're looking for you to file an accounting of the estate. We're looking for whether or not all of the assents of, either you have the assents of all the people, the beneficiaries that received distributions, or you've given at least notice that the petition's been filed, that you're looking to close the estate, the account's been filed, and at that point, either a judge or a magistrate will sign off on it. A judge will probably get involved if it's contested. Sometimes we have accounts that get filed, and they say, wait a second, I didn't get that $5,000 check that you said that I did. And so there'll be a court proceeding on that. But the vast majority of accounts get filed they get filed formally, but then are generally allowed, administratively by the magistrate.
When do you see, just using the closing statement, like when there's only, like let's say it was a husband and wife and she got everything and,
Right.
she just did a closing statement?
Yeah, and that's a simple.
Yeah.
It ends the case. It doesn't relieve you of the burden of the bond. Now that's, for some people, they get nervous about that. It's nothing really to be nervous about, because eventually that does go away. But if it's a simple estate, there's really no need to formally close the process, because wife got everything. Nobody's disputing anything. And even if somebody wanted to dispute it, they have a right to. They can come in and file their own petition. They could actually require a personal representative to file formally if they choose. So there's proceedings within the estate process itself that allow for people to come in and out of the case, whether formally or informally, and get all of their issues resolved.
So if they want to protect their interests, they might do something on their own to go ahead and into the courthouse and file something?
Sure,
Yep.
absolutely. There's always opportunities. If I always try to emphasize that if you feel aggrieved in any way, whether it's in a family law situation or in a state issue, come into the courthouse, meet with the staff, ask some questions, give us the circumstances that surround your particular concern, and for the vast majority of issues, we can resolve them one way or the other. Sometimes it's a miscommunication. Maybe the personal representative, didn't actually formally give a copy of the account, and the account's on file with the court, and the person reviews and says, "Oh, there it is. Oh, yeah, I'm all set." Or they kind of find something that really isn't right, or they realize that, wow, the personal representative, they charge $8,000 for their time. What's going on? Or sometimes the attorney's fees. We have an informal process, kind of review process that we look at in Norfolk. It's not a mandate, but it's something that the judges put in place, that we review attorney's fees on an account. And our benchmark is generally 6%. That we look at the attorney's fees and see whether or not they're approximate, if they're 6% or lower of the total value of the estate. Because usually the value of the estate kind of dictates how complicated an estate is.
I was going to say how much time it
and
would
therefore an attorney's time is valuable, and so we wanted to. But sometimes that's a big complaint, and we all hear about attorney's fees. So when we're allowing accounts, we review attorney's fees, and if the account seems over that 6% threshold, which we kind of set as kind of a benchmark.
I think that's great that you do that.
We simply require an affidavit from the attorney to say, what's up with that?
Yeah, when I was first looking into, people would say to me, well, what does normally an attorney charge for probating an estate? And I went on to the case law, I went to look, and it's nice to know that there is sort of a benchmark.
Yeah, and it was something we discussed years ago. This goes back to, I think Judge Harms was the one who, when she's since retired, but Judge Harms, dove into this and said, let's put some kind of figure on it, because some attorneys years ago would charge a third, and that really was not acceptable. Although it was acceptable back then through the court process, as well as I think the code of ethics for attorneys said you can't do that anymore. So, but we think a 6% thing was something that was reasonable, and we talked to a lot of attorneys about it and what the benchmark should be. And it is a simple thing. Sometimes cases are very complicated, and if they're a contested matter, if there's multiple businesses involved in an estate, if there's multiple properties involved, there may be more activity by the attorney than in a simple estate. So there may be times when an estate has attorney's fees that are upward 20% of the estate, and we simply ask for the attorney to file an affidavit of their fees as to why it exceeded what we believe is reasonable. And the vast majority of those are fine.
I'm glad the viewers would know that you are looking at that.
Absolutely.
Now, the other thing I was thinking about was a statute of limitations. Is there a statute of limitations of when they can file the informal versus the formal, or is it the same?
We've finally hit the stage of where statute of limitations is now real. Statute of limitations is 3 years. You have 3 years to file after the date of death to file an estate in the court. Now, that doesn't mean that if 10 years from now there's a problem, because there are a whole host of exceptions to the filing, but there is a hard statute of limitations now under the code, and it's 3 years from the date of death.
So now that would be for the informal?
For any estate. For
then
any
what
estate.
if you're over the 3 years? What happens then?
If you're over the 3 years, there's still a petition to, it depends on what you're trying to do. You can always establish heirs. Certainly real estate, to clear title is another exception to file.
And that's always the big one.
And that's usually the big one. That one is delineated in the code. And there's I think 7 or 8 of the exceptions as to what is an exception to the statute of limitations. But for that, we've tried to set a hard line of 3 years. We haven't come across it yet because the 3-year threshold just kicked in because the code, I think it was March 30th of 2012. So we're now under that. It was our belief that if you died prior to that enactment, then you were not under the code. So therefore,
there was no statute.
Deaths prior to that, you can still file. But anybody who's died since March 31st of 2012, you need to have that filed within 3 years. Otherwise, you have to come into one of those exceptions.
Okay, great. So we kind of, even though we were talking informal, we kind of went back and forth a little bit with formal and informal. But do you want to now kind of talk more about the formal process, or
Sure.
I think of it as more the one that the court supervises?
Yep, and the formal process, and I would advise the attorneys oftentimes when they first came in, I said the formal process is always something that you can do. And the formal process is very much mirrored what we used to do all the time. You would file your petition, your death certificate, your bond with the court formally, asking that the court formally admit the probate, the will to probate, formally ask that the court appoint a personal representative and formally administer the estate. The big difference is in the appointment process. In order for you to get appointed formally, you need that pre-publication. You need a publication prior to appointment. So we're going to issue you a notice of appointment that you're going to go similarly to the informal process, but prior to the appointment. You'll go and have it published in the newspaper. Usually we give you about 4 to 6 weeks to do that. Once you have published in the paper and you've provided notice to everyone that has an interest in the estate, provided we give you a date certain. Our dates we always schedule them on Wednesdays, the return date. So your return date comes, meaning publication has been made, and that I think the publication says provided it's after 10 o'clock in the morning on a certain date, and it's always on a Wednesday, you can come into the court and get formally appointed. Still, it's not judicially related to, because provided there's no controversy and there's no objection that's been filed in the case, the magistrate will review that and I'll sign off.
Oh, so the magistrate does sign off on the formal?
We can sign off on the formal as well. It's only when there's a contested matter, when an objection gets filed. Somebody gets notified and said, I don't want Geraldine to be appointed as the personal representative of the estate. I'm going to object to that matter. That'll put everything on hold. Now, you can't object to an informal. Let's say we go back. On an informal, you can't object to it. Your only remedy is to file your own formal. So that's the difference in the way the process works. But under a formal, you've given notice. Either somebody saw it in the paper or they got direct notice from the personal representative or the proposed personal representative, and they filed an objection. They said, I don't want Geraldine to serve because of whatever reason.
But don't you have to give a reason? I mean, I know I have people sometimes come to me and say, I want to object to so-and-so being personal representative, and I say, well, what's the reason? I mean, you can't, I believe that you do have to state a reason for why you're objecting.
You do have to, you can file a simple objection. You can come in at 9:59 on the date of the return date, 9:59. You can hurry into the front counter and file your objection to the estate. That halts the process. However, you are required to file a statement of objections within 30 days after the filing of your objection. And that is when you get a little bit more detailed as to why. Perhaps there was undue influence over the decedent. There was, that you're a criminal and you shouldn't have access to the person's estate. So there's a whole host of reasons, and then it becomes a very formal process in front of the judge. The side who is the non-objector or the person looking to get appointed is going to try to strike the objections. There's a whole formality goes back and forth, and that's when you really need competent legal advice. Because
And I
it's
think the other thing the viewers should understand too, if someone does object, they should have a reason for objecting, because it also costs money to object, because you're going to
Absolutely
have,
does.
you have to file the objection, you're going to have to then be in front of a judge. I mean, it's going to take more lawyer fees, and so if you don't have a real reason to object, I just think the viewers should think about that.
Yeah, you really have to figure out it. It's usually if there's some kind of real bad representation by the personal representative that I think undue influence usually is the biggest thing. Mom's passing away,
That's what I was thinking
and she had a valid will, and then all of a sudden the sibling from California flies in, gets a new will done, and all of a sudden she's the new beneficiary of the 100%, while mom was suffering from dementia or Alzheimer's or something awful in the nursing home. That's usually the scenario that we come up with, and there was undue influence that mom never wanted to rewrite that will. She was in the hospital and she was forced to do so. So that's usually the one that we see, is that there's a situation. It's tragic when families don't get along, but it does happen, and so that's one of the objections. But you really need to have a valid. It's not because you don't get along with your sibling, or sometimes it's even a second marriage, and the stepkids aren't happy, and so. But you really need to have a valid reason to object.
Oh, when you were talking about that, for some reason came to mind was the memorandum. We didn't mention that. Now that, there used to be a mention of a memorandum in a will, and it was,
sure.
And now that personal representative is bound by the memorandum that's attached to the will.
Correct. If there's a memorandum that states, certain things that are being, that they wanted so-and-so to have something, you're obligated to make sure that memorandum is followed to a T.
Only because when you were talking about that, I was thinking a lot of times that's the problem between siblings is, I wanted the ring.
Yeah. Who's getting the ring? Who's getting the trinket or the heirloom? And
yeah, I really encourage that my clients go ahead and take advantage of the memorandum and date and sign it, and make sure that they list who they want to get what.
Yeah, it's and I've seen this happen quite a bit, because when we write wills up, when people write wills up, sometimes they are very general. I leave all of my tangible personal property to my 3 loving children equally to share unto each other. That gets problematic, and when there's the silver kitchen set, or there's the old china that was passed down through the generations, whether it's a monetary or value or an heirloom that has a sentimental value. People, when they're putting together their estates, they should take a physical inventory of their stuff, and for those things that are sentimental, put it in your will specifically who should get the ring, who should get the necklace, who should get the jewelry. And then the rest of it, who about the dining room set or whatever, I guess could just go amongst whoever wants it. But the more specific you are in a will, the less likely is going to be cause for bad feelings after you pass away. So
that's a really good point. I know my kids are already saying, I want this. I'm like, thanks. The other thing I was thinking about too is, I know that we mentioned creditors, but do you have anything else you want to add as far as, I know the creditors have 1 year. Some people think they can wait the 1 year from date of death, and then they don't have any problems, like without publishing. I just didn't know if you wanted to speak to that.
Creditors, creditors have rights, and it's. I often give, I have my own personal example of a creditor who, when my dad passed away, and he had leased a vehicle through, I'm not going to name the company, but he leased a vehicle, and, they leased to an 84-year-old man, and basically tried to come after the estate to sue us for the value of the car, because he passed away, I think, 2 months into the lease. Oh. And, I think they tried to sue us for like $6,000, and I refused to. I wasn't going to let up. They signed the lease with him, and he wasn't obligated to pay. But it tied up the estate when they filed the claim against the estate. The issue came, however, in terms of a creditor, when they file a claim, they can file a notice of a claim with us at the probate court, but in order for them to perfect their claim, they need to file a separate lawsuit, either in the district court or the superior court. So it depends on the value of the claim. So if it's under $25,000, they can file in the district court. If it's over 25, they got to go to the superior court and get an actual judgment on that credit that's owed. And that judgment would then be filed with the probate court, and that would cause the personal representative to have an obligation to pay that debt. Until that debt is perfected, you're not obligated to pay.
But that's why it holds up an estate.
But it does hold up the estate, and you're concerned. Notices of claims come in all the time, mostly from credit card companies. We get Discover, Visa, MasterCard. They're always filing claims because they scour. These days with the internet, as soon as a death gets recorded, it's on the internet, and so most of these national agencies, these national corporations, the banks, they'll find out. And sometimes Medicare, that's the other issue, is that you have the state, if you have a decedent that's been in a nursing home and there's been payments being paid, there may be a lien that you're required to send them some dough. So there may be a payment that's owed to the Commonwealth of Massachusetts. So that can tie up the estate. So creditors certainly have a vested interest in the estate, but the day-to-day creditors need to make sure that they file a separate lawsuit, get that credit, get that debt on a judgment, then file that with the court so that the personal representative is obligated to pay.
And depending on the court backlog, that's what holds up the estate.
Right, and then some estates, can be held up for years. Whether it's a creditor battling, or it's the siblings, or some lost beneficiary, or somebody that was written out of a will, and that happens quite a bit. People will often write children out of the will for whatever reason. So and so Johnny abandoned the family years ago. I've taken care of him elsewhere, and I've specifically omitted him from this will. Well, Johnny can still come back and object to it and say, I don't want to. I was entitled to something, and so there's a variety of things that can hold up an estate. But by and large, they should be settled within a year, and if they're not, then you're obligated to be out there and account for it on an annual basis, and until it's finally closed.
So this has been great. I think there's been so much information given to our viewers today. Do you want to just kind of maybe we can wrap it up by just reviewing like the voluntary administration, the the informal, and the formal?
Yep, so voluntary, you just have to think no real estate, assets under $25,000. File a voluntary, very simple. Informal, fairly intact estate, no controversies, all heirs are properly we know who they are, there's no minors, nobody under incapacity. Informal, 7 days after the date of death, probably appointed a week after the filing. Formal, might want to secure the real estate a little bit more formally. There might be a controversy, there might be a minor, or that's just an easier way for you to go stylistically. You want court intervention, you want the court to supervise it. You go formally. It's a little bit more of a long process formally than informally, but the outcome can be the same. And that's the basic process. I always advise folks, and I usually try to wrap things up when I talk about estates. The best way to avoid problems is to properly plan, and that's why you look for an estate planning attorney that can sit down with you, whether it's in the first instance or if you're reviewing it. And I always advise folks, you ought to be reviewing your estate plan every couple of years, or when there's a life-changing moment, you have a child or somebody passes away, you really have to review this with the proper documents in place. Not that you can avoid probate, and a lot of estate planning attorneys say, well, how to avoid probate. Probate is not this monster. It's a process, but it's not overwhelming, and I think it's something that everybody can get through fairly simply.
And sometimes I tell my clients, you don't need all these trusts, just because a lot of times they were thought, if I have a trust, I avoid probate, and probate is, and I say,
probate is not that bad.
It's not that bad.
Especially
now with informal too.
The toughest thing with probate, and the only thing that is it's a requirement, is that the whole creditor issue is the estate has to be open for a year, and technically before it can be formally closed. So sometimes that causes problems, but I've seen horrendous problems with the trust issues. Trusts are a great tool under the right circumstances. I see people putting things into trust that they should never do. They're putting trusts into their kids' names, and you're basically giving away your house. And what happens to your child who possibly gets into a divorce or gets into a car accident and gets sued? Well, you're out of your house. So there's some complicated issues relative to trust that I think sometimes people rush into. Estate planning properly done get through the probate process. We're not the monsters in the room. We can get you through the process fairly easily. And the things to avoid that I always tell people, part of the estate planning process, not just get your will in place, but make sure you get a good the power of attorney in
Durable
place.
power of attorney,
so you can
healthcare
avoid
proxy,
the healthcare proxy. That I would wholeheartedly try to avoid having to go to the court to get guardianship or conservatorship of a loved one who becomes incapacitated.
And I always tell everyone that's the biggest part of your durable power of attorney, is that section of your durable power of attorney dealing with guardianship and conservatorship.
Absolutely.
I mean, and when my kids turn 18, they get one.
Yep, and it's a great tool. It's a great tool to have, and just that part of the estate planning toolkit. And most of us have simple estates. We don't have the multi-million-dollar businesses being run and the houses all over the place. We have our house and we've got a bank account and we got a car, but a will properly drawn up will take care of all of those things for us. And if God forbid we become incapacitated, that power of attorney and that healthcare proxy can cause so much assistance rather than anxiety for our loved ones if that happens.
Absolutely. Thank you so much for being here today.
This has been wonderful. I've enjoyed every minute of it.
And I'm not just saying it because I have you here and I practice in Norfolk County, but your office is amazing. I mean, I've never once gone down there and not had someone be very helpful if I had a question, and everyone talks about Norfolk County.
Yeah, I'm thrilled to be the register there. I have a phenomenal staff, and I never get shy away or get sick of hearing the accolades, but those aren't for me. They're for the staff is great. Our front counter staff, our back operations, everybody is a working part of that organization, the judges staff. So
the judges are great
it's
too.
what happens when you get a functioning court with managers that get along, and they pay attention to their employees' needs as well as the public. So that's what we focus on doing in Norfolk.
Well, again, thank you so much. And for my viewers, remember, until next time, it's simply legal.